In the matter of Alex Ortman versus Cameron France, this matter is before the court on the defendant mother's motion for supervised parenting time for the plaintiff father. This hearing is being conducted via Zoom. Present is Attorney Christina Hills representing defendant mother. Ms. Francis present. In addition, Attorney Russell Smith is present representing the plaintiff. Alex Ortman, Mr. Ortman appears to be present with Mr. Smith. Good morning, everyone.
Morning,
Good morning, Your Honor.
The parties have conferred this morning with Mr. Walker from the front of the court, who has provided the court with the following recommendation. That plaintiff father shall provide a letter from his counselor with an update as to how counseling is going, and with the counselor's recommendation as to how often he should be attending sessions. And that update letter will be provided to Ms. Sills on or before June 10th, 2024. If either party has a bench warrant issued for their arrest, then their parenting time shall be suspended until the bench warrant is no longer active. The issue of defendant's request for psychological evaluation and supervised parenting time on the part of the plaintiff father is reserved. The party shall appear back for his court to review parenting time July 9th, 2024 at 10 a.m. via Zoom. That is a recommendation. Ms. Sills, is this recommendation agreeable with your client this morning?
It is, Your Honor. She has some significant concerns as we set forth in the motion. However, there are some hearings that are set to take place in June. This allows us to see what happens with those, and it also allows us to get that letter from the counselor. So she is willing to go along with that at this time. However, I've also explained to her, and I think Mr. Ortman is on notice as well, that if there are any indications that the children are being directly involved in any of these sorts of allegations, that we will be immediately filing for ex parte relief and in the form of his parenting time being suspended.
All right, thank you, Ms. Sills. Mr. Smith, is this recommendation agreeable with your client this morning?
It is, Judge. Thank you.
Would assume that Mr. Ortman is actively engaged in counseling. Is that correct on a regular basis, Mr.
Yes,
Smith?
he is, Judge.
Okay.
He'll continue that.
Okay. Obviously, the courts, obviously, if the parties are in agreement, the court will adopt the recommendation. The court, was there any discussion, Ms. Hills, this morning in terms of who were watching the children on the evening of March 24th?
There was not. He lives with his parents, so it was our understanding or belief that they were with them. But that's certainly information which could be helpful. And we obviously were very disturbed that these allegations occurred during his parenting time.
Mr. Smith, does Mr. Ortman reside with his parents?
He does, Judge. And
that's where parenting time occurs?
yes. And
right. Okay. All right. Hopefully Mr. Ortman can address whatever issues he's going through right now. They're obviously a legitimate concern, but anyway, the court will adopt the recommendation of Mr. Walker this morning, and we'll put this back in our docket July 9th at 10 a.m. Ms. Hills or Mr. Smith, either of you want to voir dire your respective clients regarding this recommendation?
Yes, please.
Hills, can we get with Ms. France, please?
Ms. France, have you heard the recommendation and agreement placed on the record?
Yes.
Do you have any questions about it right now?
I do not.
Do you understand it?
Yes.
Okay, and you understand the reasons the recommendation was made based on the discussions with Mr. Walker?
Yes, I do.
And at this point in time, do you believe that moving forward in this way is in the children's best interest?
Yes.
Okay. Nothing further.
Thank you, Ms. Hills. Mr. Smith, do you have any questions for Ms. France or Mr. Ortman?
I don't, Judge. Thank you.
All right. Ms. Hills, any questions of Mr. Ortman?
No, Your Honor. Thank you.
All right. All right. The court will adopt the recommendation. And that will conclude this hearing. I'll zoom out. Have the rest of the day.
All right. Thanks, Your Honor. You too.
Thank you, Your Honor. Thank you.
Conducted via Zoom. President Attorney Russell Smith, representing the plaintiff father, Alex Ortman. Mr. Ortman is present with Mr. Smith. Good morning, Mr. Smith.
Good morning, Judge. Morning.
In addition, Attorney Christina Hills is present representing defendant mother Cameron France, and Ms. France is present. Good morning, Ms. Hills.
Morning, Your Honor.
Parties have conferred with Ms. Patrick this morning, who has provided the court the following recommendation. Plaintiff father's parenting time should be every other weekend, Friday at 5:30 p.m. until Monday at 7 a.m., as well as every other Thursday from 5:30 p.m. until Friday at 5:30 p.m. for the summertime. Issue of parenting time for the school year is reserved. Text messages and police reports shall be provided to plaintiff's therapist. Plaintiff will continue his therapy once a week. Parenting time exchanges will be conducted at the Bedford Police Substation by defendant and paternal grandparents. The parties shall continue to use app close to communicate regarding the children, and the parties will appear back for the court to review parenting time September 4th, 2024 at 8:30 a.m. That is the recommendation. Mr. Smith, is this recommendation agreeable with your client this morning?
Reluctantly, yes, Judge.
Thank you. Ms. Hills, is this recommendation agreeable with your client this morning?
I would also indicate reluctantly, Your Honor, I do think the recommendation, hopefully, if followed by Mr. Ortman, puts us on the right track to getting him back in a position where he can communicate and co-parent with my client without engaging in a lot of communication, which is completely inappropriate. And I would just note that if there are any more communications which do not relate directly to the welfare of the minor children, that I'll be filing a show cause and setting that for hearing as well. The communications have just been absolutely uncalled for and are very disturbing to my client. They just need to stop.
That's noted for the record, and the court's confident Mr. Smith can appropriately counsel his client in that fashion.
Judge, I've advised Mr. Ortman regarding this matter, and I'm hopeful that he can follow my advice. I'm very hopeful, Judge. So I have spoken with my client ad nauseum regarding that issue, and the communication is supposed to be regarding the welfare of the children only. Do you understand that, Mr. Ortman?
Yes, sir.
Okay.
Who will provide the text messages and the police reports to the plaintiff's therapist?
I will, Judge.
Okay. And you'll copy Ms. Hills with your correspondence with the therapist?
I will, Your Honor.
Thank you. All right, Counsel Joe Bard, do your respective clients this morning.
No, Judge.
All right, the court would like to thank Ms. Patrick for her assistance this morning, as well as, of course, Attorneys Hills and Smith for helping facilitate this temporary arrangement. Hopefully it will work out. Mr. Ortman, do follow the advice of Mr. Smith.
Yes, sir.
You'd be well served by doing that if you want to move forward in a positive fashion. All right, the court will adopt the recommendation, and we'll see everyone back here then on September 4th at 8:30 a.m.
Thank you, Your Honor.
Thank you. Everyone can zoom out and have a good rest of the morning. Thank you, Ms. Patrick.
Thanks, Ms. Patrick.
Matter, Alex.
For the record, this matter is before the court for the purpose of reviewing the outstanding issues. Primarily, the court recalls, is plaintiff father's parenting time. This hearing is being conducted via Zoom. President is Attorney Russell Smith, representing the plaintiff, Alex Ortman. Good morning, Mr. Smith.
Good morning, Your Honor.
Mr. Ortman appears to be present with Mr. Smith. In addition, Attorney Christine Hills is present, as well as her client, the defendant mother, Cameron France. Good morning, Ms. Hills.
Morning, Your Honor.
Parties have conferred with Ms. Pratt in front of the court this morning, who has provided the court the following recommendation. Father's parenting time shall be every other weekend, Fridays at 5:30 p.m. until Sunday at 6 p.m. In addition, fathers shall have parenting time every other Wednesday, 5:30 p.m. until 7 a.m. Thursday morning. On the week, they does not have the weekend parenting time. Exchanges shall continue at the Bedford substation, and fathers will not be involved in the exchanges. Alex Ortman shall attend counseling every other week. The party shall continue to communicate via app close regarding the children. The party shall return to this court to review parenting time November 19th at 8:30 a.m. via Zoom. That is a recommendation. Mr. Smith, is this recommendation agreeable with your client?
Judge, I don't think it is. We've talked about it. He wants some additional parenting time because of the preschool schedule. The recommendation would eliminate a Sunday overnight. Presently, he has Sunday overnights till a Monday. And what he proposed was 3 weekends for him as a resolution. That was rejected. We would ask that the court consider that, or as an alternative, that his Wednesday parenting time overnight be every week versus every other week. Fact of the matter is, since the last hearing, Judge, there have been no incidents of any type between the parties. He's satisfied the order that the court entered at the last hearing, and everything has gone swimmingly. He's just asking for some additional time. He loves his kids. He wants to spend more time with them. And I would urge the court to consider the 3 weekends as a solution.
Ms. Hills,
Your
court
Honor,
does note that the parenting time has been shortened from the last order of the court, taking away the Sunday overnights.
yes, Your Honor, the court had reserved the issue of school year parenting time so that we could address that today. It's my understanding this is a recommendation for the school year. We will be back November 19th for a review. The parties also need to choose a kindergarten, so there will be lots of opportunities for them to discuss summer parenting time moving forward. And we're very hopeful that Mr. Ortman can earn back the trust that he had again lost with my client, and that they can get to a more normalized parenting schedule with more parenting time for Mr. Ortman. We are not there yet. Mr. Smith mentioned that there had been no issues, and that is true as far as the communication goes since the last review hearing. However, just in the meeting with friend of the court this morning, Mr. Ortman made some very concerning statements that still lead one to believe that he does not accept his own role in where he's at right now with his parenting time. He continues to put the blame squarely on my client in large part for his issues that he's had with co-parenting and with just completely inappropriate communication. We are very glad that that has not happened, that he's been able to do what he needs to do since the last court hearing, but I think it's clear that there's a lot more work that needs to be done on his part in therapy. So hopefully he will continue that. This schedule provides some stability for Arlo. I realize it's preschool, it's Monday, Wednesday, Friday, but the child does need some stability during the school week. We have some limitations, which were the result of Mr. Ortman's actions in terms of the logistics of the exchanges. And those are taken into consideration in the Ms. LaPratt has made as well. Mr. Ortman has acknowledged that he is not available himself during the week to be with the child, and that the children would be primarily with his parents. My client did suggest that she would be willing to do Monday evening when he has not had the weekend for 5:30 to 7:30, so that he would have some contact during that more extended period where he otherwise would not see the children. That was not accepted by him. But I do believe that this schedule that's proposed for the school year does what's best for the children. And my client has even offered again an evening in addition to that. So we are asking that the court adopt the schedule that's been recommended for the school year.
Anything further, Mr. Smith?
I'm sorry, Your Honor, I didn't hear that.
Anything else on behalf of Mr. Ortman this morning?
Yes, Judge. My client has worked very, very hard to get to this point. He's doing everything that he's supposed to. He doesn't want to move his time backwards with the children. He wants to move it forward. He's recognized the fact that his relationship with Ms. Franz is over. I think she has remarried. He's fine with that. He just wants more time with his children, and he's worked very hard to get that, Judge. So when the court read the recommendation from the friend of the court into the record, did it indicate that his counseling would be every other week going forward? I can't recall if I heard that or not, Judge.
A week, yes. He shall attend counseling every other week.
Very good. Very good. And Judge, I just ask you to give Mr. Ortman the benefit of the doubt. He's earned this. He really has. So I just ask you to award him the 3 weekends per month. Thank you.
Well, the court would note the parties did confer at length this morning with Ms. Pratt, and the court has confidence in Ms. Pratt being able to assist the court with these matters. And there is a review date. If in fact it's not acceptable, Mr. Smith, we'll set an evidentiary hearing, because the court is quite honestly tired of these parties come back every other month. We should have an evidentiary hearing, be done with parenting time unless there's a change in circumstances. We bring in the counselor. You have testimony about Mr. Ortman's mental health. So either the court's inclined to either adopt the recommendation with a review date, otherwise we'll just, with no review date, let's set an evidentiary hearing and be done with it. I'm really, I just have this case coming back every other month for what? The last 12 months? There's got to be some finality to this. So, Mr. Smith, the court either adopts the recommendation with a review date or we'll set up for an evidentiary hearing.
I'm sorry, Judge, I didn't hear your last comment.
The court will set an evidentiary hearing if you oppose this recommendation.
You're asking me if I oppose it?
Was a hearing.
You want to go to a hearing?
I don't know what that entails.
1 second, Judge, if I might mute myself. Judge, I've spoken with my client, and would you want the Monday? It's part of it.
Yeah, and Wednesday.
Yeah.
Yeah.
I've spoken with my client, Judge, and if previously Ms. Hills has offered the Monday 5:30 to 7:30, along with the every other Wednesday overnight, if that could be part of the package, my client is agreeable to the court entering that order.
That would be in lieu of the Wednesday overnights?
No, it would be in addition to the Wednesday overnight.
The Wednesday overnight is every other week as recommended when Mr. Ortman does not have the weekend. And then the Monday following Ms. France's weekend is what she had suggested, 5:30 to 7:30.
Correct.
Are you still agreeable with that?
Yes.
Okay.
So 1 week, it'd be Monday overnight, and the next week would be Wednesday overnights?
The Monday would just be 5:30 to 7:30, Judge. It would be.
Oh, just the evening hours.
Alternating, alternating Mondays, 5:30 to 7:30, and alternating Wednesday overnight.
Understood. And that's what you were referring to, Mr. Smith?
Yes, Judge.
All right, if that's agreeable, it sounds like it is, Ms. LaPrade, you can add that to this recommendation. And yes, hopefully the parties can, between the two of each other, discuss the childcare issues, whether they understand the oldest child is 4 years old. I don't know if it's a pre-K program or a daycare. Hopefully they can continue to discuss what's best for their children, including parenting time. And I think it's important that Mr. Ortman continue his counseling. I don't know, has he received any recent reports from the counselor, Ms. Hills?
We just got some this morning, Your Honor. I have not been able to dig deeply into them yet, but it does appear he's going and addressing his issues with the counselor.
Okay. All right, well, thank you, Ms. Hills and Mr. Smith. We'll add to the recommendation, Mr. Pratt, alternate Wednesdays, evenings.
Yes,
Now,
sir. I believe it's Monday, every other Monday after Mother's Weekend.
Right.
correct. All right, with that, the court will adopt the amended recommendation, Mr. Smith and Ms. Hills, and we'll put this back on our docket November 19th at 8:30, and hopefully the parties can make some progress on their own.
As long as the communication is appropriate, my client is more than willing to co-parent.
That would be wonderful, Judge. That's what I've been hoping for all along, is at some point the parties will have the ability to exchange ideas regarding the children and have an actual dialogue. That would be a wonderful move forward, Your Honor.
Agreed.
Well, thank you, Mr. Smith, and the court's confident that with two very experienced family law practitioners, they can appropriately counsel their respective clients in that regard. All right, court will adopt the amended recommendation. We'll send one back on November 19th at 8:30.
Thank you, Your Honor.
Thank you, Your Honor. Have a good day.
Thank you as well.
France.
For the record, this matter is before the court this morning for the purpose of reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. Present is Attorney Russell Smith, representing the plaintiff father, Alex Ortman. Mr. Ortman is present with Mr. Smith. In addition, Attorney Christina Hills is present, representing defendant mother, Cameron France, and Ms. France is present. Good morning, everyone.
Good morning, Judge.
The parties have conferred at length with Mr. Pratt this morning from the front of the court, who has provided the court the following recommendation: that father's parenting time shall be specific as follows. With respect to holidays, parties shall follow the Monroe County Front of the Court holiday schedule. Otherwise, parenting time for fathers shall be as follows. Fathers shall have every other weekend, Fridays at 5:30 p.m. until Sunday at 6 p.m. In addition to every other Wednesday, 5:30 p.m. to 7 a.m. Fathers shall also have the Monday following Mother's Weekend from 5:30 p.m. until 7:30 p.m. The exchange of the children, I should say, shall occur at the Bedford substation of the Monroe County Sheriff's Office. The parties have agreed to mediate with Mr. Pratt on January 9th, 2024 at 8:30 a.m. And the issue of parenting time will be reviewed by this court February 5, 2025 at 8:30 a.m. That is a recommendation. Should the court now review parenting time on the subsequent mediation if necessary? Mr. Smith, Ms. Sills, or do you want some breathing room between the mediation and the review?
Your Honor, what we discussed is if we do reach an agreement at mediation, we could vacate that review hearing. If we do not reach an agreement at mediation, I think that extra time following mediation could be helpful in the court making some decisions on what to do. Just a bit of extra time to see how things go with Mr. Ortman, a few more counseling sessions, or a couple more post-mediation, and just more opportunity for him to show good judgment or the lack thereof, as the case may be. But I think that extra time could be helpful.
All right, understood, and that makes sense, Ms. Sills. Thank you. All right, Mr. Smith, does this recommendation agree with your client this morning?
Well, no, Judge, but quite frankly, I think we've made progress today. The parties were able to speak cordially to one another, and my client has some holiday parenting time coming up. Hopefully, everything will go smoothly between now and the time of mediation, and we can mediate it to conclusion on the date set and eliminate the other court date. That's our hope, Judge. So we wanted to move the meter today. We weren't able to get that done, but I think that both parties understand that it would behoove them to move the meter forward as things go along in this matter, Judge. So although we're not delighted about the recommendation, we are willing to accept it at this point with the idea that when we return that things will move forward. So yes.
All right, thank you, Mr. Smith. Ms. Hills, is this recommendation good with your client this morning?
It is, Your Honor, and my apologies to Ms. LaPratt. I should have raised this issue with her, but it is our understanding and expectation that Mr. Ortman would continue his every other week counseling in the interim.
Any objection, Mr. Smith?
No, Judge. I think that would be fine. Mr. Ortman, do you have an objection to that?
No.
No, I think it's helpful, Your Honor.
All right, perhaps we can, Ms. LaPratt can do her magic and add a sentence to this recommendation for the court to adopt that the plaintiff father shall continue his counseling every other week. All right, with that addition, Mr. Smith or Ms. Hills, do you wish to voir dire your respective clients?
No, Your Honor.
No, Judge.
Well, obviously, the court would note they're both involved in these discussions for the last hour. Very well. I would like to thank Mr. Pratt for her efforts this morning, as well as, of course, Attorney Smith and Hills for helping the parties reach this agreement. And the court will accordingly adopt the same with the addition that the plaintiff father shall continue counseling every other week. And that will conclude this hearing. Everyone can zoom out and have a good rest of the day.
Great. Thank you, Your Honor.
Thank you, Judge. You have a good day.
We'll call the case of Rochelle Gonzalez versus Joshua Perry. For the record, Mr. Perry is appearing via Zoom from the Monroe County Jail this morning. Also, the president is Monroe County Front of the Court Attorney Rebecca Hicks. Ms. Hicks, can you provide the court some information about Mr. Perry?
Certainly, Your Honor. Yes, this is an arrears only case. The child emancipated January of 2023. The last payment received was October 25th of 2021. The current balance is $1,131.31. This bench warrant resulted from Mr. Perry failing to appear at a referee show cause hearing in September of 2022, where a bench warrant was recommended. There is a previous finding of contempt. It's from January 23rd of 2012. It is a first finding, and we do have a 43-day balance.
Thank you, Ms. Six. Do you understand that, Mr. Perry?
Kind of.
Do you understand everything Ms. Six said this morning?
Yeah, I understand.
Okay. Are you being held in jail on any criminal charges?
No, sir.
Okay. Are you currently employed?
Yes, sir.
With whom are you
Kind of.
employed?
I'm kind of like self-employed at the moment, sir. I'm
Okay.
still trying to. I'm working on getting a normal job too.
Okay. Well, the old $1,100 in outstanding child support, and this file will not be closed out till that is paid. You've not made any payments since over 2 years.
Well, the last time I was in a hearing with Wes McKee, my Rochelle was also there, and she asked him, and this was like in 23 or 22, she asked him to forgive my arrears. I had a warrant, sir. I would, if I would have knew I had arrears, I would have been paying on them. I'm very sorry.
You were mailed a notice to appear. Why didn't you appear?
I never got the notice, Your Honor.
Okay, what's your address?
I did not. I did not receive it in the mail.
What is your current mailing address?
319.
Okay, that's a problem, Mr. Perry. The court file reflects an address. You have an obligation to keep the front of the court in front of any address, and so obviously you're not staying on top of things, Mr. Perry. So in other words, you got who do you currently live with?
I live with Rochelle, and I kind of live between two places right now.
All right, you got to check your mail. You need to come over to the front of the court first of all and change your address in writing when you get out of jail, so you can mail notices. And right now you got 43 days hanging over your head, Mr. Perry. So the court's going to impose a jail sentence. You can be released upon posting a cash-only bond. So suggest to the court, how much can you? The court would like you to get out of jail so you can get a job. How much can Rochelle or someone else pay? Of course, Rochelle can may be able to waive some of these arrearages, but only if they're owed to her, not the state of Michigan. Ms. Six, can you tell her these all owed to Ms. Gonzalez, or are they some owed to the state of Michigan?
There is about half owed to Rochelle, and the other half is owed to the state of Michigan. There's looks like $600 is owed to Rochelle at this point.
All right. So, Mr. Perry, Ms. Gonzalez could come in and waive up to $600 of these $1,000 in arrearages, but that $500 is owed to the state of Michigan. That cannot be waived. So, how much can you get? This way, reach out to family and friends to post a cash bond. You think
I think I could probably get like $200 to be able to get out.
Ms. Six, any objection to a $250 or $300 cash bond?
No, Your Honor, no objection. I'll leave it at the discretion of the court.
Mr. Perry, anything you want to say before the court imposes sentence?
No, Your Honor, other than I want to make sure that you understand when I do get out of jail, I will get my arrears caught up. I didn't understand. I didn't realize that I owed $1,000. I did not realize I even owed anything at all. As you know, I see my son all the time. Well,
I mean, who lives at South Tigerford? You're not paying attention to these things. Mr.
I
Perry.
haven't lived in that house since 2018, Your Honor.
All right. In any event, the sentence of the court, sir, you're ordered to serve 43 days in Monroe County Jail as follows: 10 days immediate. Is he entitled to 1 day credit, Ms. X?
Yes, Your Honor.
Okay, we'll give you credit for 1 day. So that means you serve the next 9 days in jail, but you can be released immediately upon posting a $300 cash bond. So, Mr. Perry, reach out to Rochelle, other neighbors, to see if you get $300. Now it's going to apply 100% towards your arrearages. And if you can post that, you can be out home for dinner tonight. If you can't post a $300 cash bond, you're going to serve the next 9 days in jail. And then we're gonna give you a date to come back from before Ms. Hicks for review. Ms. Hicks, what do you suggest for review dates?
July 23rd at 1 p.m.
Okay, Mr. Perry, there's still any arrears, even if you post $100. You were to appear before Ms. Hicks for review July 23rd. I'm sorry, what time, Ms. Hicks?
1 p.m.
Thank you. July 23rd, 1 p.m. You can appear via Zoom or you can appear in person, Mr. Perry. July 23rd, 1 p.m. A copy is ordered. We mail it to you at this Rosser Street address. A copy will also be emailed over to the jail. You get a copy of this before you're released. When you get out of jail, you come over to the front of the court. Talk with your caseworker. Talk with Ms. Hicks. You need to fill out a form changing your address so you receive all future notices. And make sure you appear on July 23rd. You need to start chipping away at this obligation. And of course, if you post $100 bond, that can be applied to a state of arrears. Rochelle can come in and she can waive $500 if she wants. But at this point, you're served 9 days in jail unless you can post a $300 cash. So make some phone calls.
Yes, sir.
All right, any questions?
No, sir.
All right, so you can step out. Thank you, Ms. Hicks.
Thank you, Your Honor. I'll get that order uploaded shortly to your queue.
We'll call the case of Alex Clifford Lewis versus Samantha Jean Hudick. For the record, this matter is before the court on the plaintiff father's petition for parenting time. This hearing is being conducted via Zoom. President Attorney John Danielski representing the plaintiff petitioner Alex Clifford Lewis. Mr. Lewis appears to be present with Mr. Danielski. And ma'am, you are Samantha Hudick, is that correct? All right, good afternoon. The parties have conferred this afternoon with Ms. Andrus from the front of the court, who has provided the court with a fine recommendation that the parties shall share joint legal custody on a temporary basis without prejudice of the 4-year-old minor child. Parenting time shall be as follows. First of all, the parties shall exchange minor child for parenting time purposes at the Woodhaven Police Department. Mother shall have parenting time on Mondays and Tuesdays. Father shall have parenting time Wednesdays and Thursdays. And the parties shall alternate the weekends from Friday to Monday. All exchanges shall occur at 6 p.m. Further, it's recommended that the court order that neither party shall take the minor child outside the state of Michigan unless agreed to by both parties. So in other words, if someone's going to Toledo, someone's leaving the state of Michigan, you need to inform and get the consent of the other party. All right, that's the recommendation. Mr. Danielski, is this recommendation agreed with your client this afternoon?
Yes, Your Honor.
Thank you. Ms. Hudick, do you understand the recommendation?
Yes,
Do you have any objection to this recommendation?
yes.
Okay, what is your objection?
I think it should only be monitored parenting time. Like where his family, like she would be at his family's house with him.
Why do you believe that's necessary? It's a 4-year-old child. The child's not 6 months.
She's not old enough to call me if she needs anything. He's threatened me numerous times, and because his behavior recently, when he told me that if he didn't get Ivy, that he would kill Ivy, then kill me. And then later that night, he got a ride from a friend. Later that night, he told that friend that he would kill himself if he lost me and Ivy.
Well, he can do whatever he wants if he wants to kill himself or injure himself, Ms. Lewis, but Ms. Hudick. But if he's threatening you, you should petition the court for a personal protection order. It does not protect property. It doesn't protect himself. It just protects you if he's threatening you with physical harm or violence. But that's another matter. The question is whether or not your daughter is safe in his presence, and we need, other than just your opinion, what kind of behavior have you exhibited that would suggest to you that he's a danger to your daughter and his daughter as well? People say things when they are upset, but unless he has some psychiatric condition that you can provide this court proof of he's entitled to parenting time.
Yes, she told me that I would have to turn that in. When right before Ivy's first birthday party, he tried to self. He had a gun head, and I had to call the cops, and he was in the mental institution for a week.
That was what, 3 years ago, correct?
Yes.
What's happened in the last 6 or 9 months?
In the last 6 or 9 months, about 2 months ago, he broke his toe, and that scared me because he didn't cry. And the reason he broke his toe is because it was like 2:30 a.m. I'm just trying to cut to the chase. It was like 2:30 a.m. Ivy's screaming. She was in her bed, next to our bed in our room, and he got up, and out of a rage, he picked her up. He had broken his toe right when he got up out of bed. They called it a spiral fracture. And he picked Ivy up and he took her to the couch and put her on the couch. And then he hollered at me saying, "I think I broke my toe. I've broken bones before." And I took him to the hospital and they looked at it, but it was the fact that he did not cry. He was that mad that he didn't even realize he broke his toe until after he had picked up Ivy and moved her to the living room.
Okay, I'm trying to understand what that has to do with his ability to care for a child.
His ability to care for a child. It's more of the threats that he only has his mother and his cousin that live in Michigan, and all of his other family live either out of the country or out of the state. And he's told me that he would take off with her and I would never see her again.
Well, if he did, he'd be charged with, first of all, felony offense called parental kidnapping. This court's order that he shall not remove that child from the state of Michigan without your permission.
Anytime that
Yanowski, with whom does your client reside?
Your Honor, he's got a 2-bedroom apartment. There were threats of violence on him, so he left on May 3rd. I filed this case on May 7th, and he's already got a 2-bedroom apartment, and I can he came in with his mother, very nice lady, and he's already signed a lease, and I can show pictures of it. I did show pictures to the friend of the court referee, Your Honor, and he's got it all set up, and I can show those pictures to you.
Right. The court's question is, with whom does Mr. Lewis reside?
I'm sorry, Your Honor. He's living by himself, but his mother's in the area. She came in with me.
Okay, so his mother lives close by. She lives here in Michigan.
Yeah. She came in and paid a retainer, Your Honor.
So if Mr. Lewis needs assistance, his mother is available, can help. Is that correct?
Yes, Your Honor.
All right. So that gives some relief, Ms. Hudick, the fact that patrol grandmother's close by and can be contacted and should be available to assist if Mr. Lewis is having any difficulty. So your objection is to overnight parenting time, or you want all parenting time to be supervised?
for now, I want supervised parenting time, normal supervised parenting time.
Your Honor, these allegations the mother's making are false. Your Honor, I tried to avoid getting into the mud. I got all kinds of things I can say about the mother. Regarding spanking the child, screaming at the child, screaming at my client, and these allegations that she's making are not true. He hasn't threatened to kill anybody or anything like that, Your Honor. So they lived together for 7 years, Your Honor, up until May 3rd, and then he didn't want to be around. Mom wanted to go out drinking and getting drunk, and with the child, Your Honor, taking the child to a farm party where there was a shooting. I have a police article. It wasn't that night, but there was a shooting there. I was trying to not get into the mud on this. Okay, they've equally taken care of this child. They've lived together for 7 years, and he was changing diapers, doing everything for this child, Your Honor. So, and they both had the same work, almost identical work schedules, Your Honor. And this is a fair resolution.
When Mr. Lewis is working, who will watch the child?
There's a daycare provider that is used, and they can use the same daycare provider. Mom's been using the daycare provider.
Why am I muted?
My client's mom, I believe, also works from home. She's a budget analyst for the military, so he probably will utilize her as well, I would imagine. But if there's some problem, there is a daycare provider.
I'm muted.
And obviously, Mr. Lewis should inform Ms. Hudick where the child's going to be when he's at work, whether it's at his mother's or daycare, just a common courtesy. And likewise, Ms. Hudick, you should inform Mr. Lewis where the child's at when you're working. But the court is not convinced or satisfied that the dad is a danger to this child based on your allegations. And there's no documented proof, Ms. Hudick, but the court will, in fact, the court's going to adopt the recommendation. We're going to set this for review. We can come back and maybe 40 days. If there's an issues, we can address it at that time and we can modify parenting time. Parenting time is always subject to modification. If there's issues, concerns, we can draw back this parenting time. You had a question, Ms. Hudick?
I have, it's already in the records. Last year on March 4th, he had a DUI. So he's the one that was drinking.
Was the child in his car?
No, the child was not in the
Right.
car.
Obviously, the child's in the car, that's one thing, but if he's not exposing the child to those risks, it's not a significant concern to this court. But we're gonna look at a review dates in about 40 days.
Yes, sir. I have Wednesday, July 10th at 9 or 1:30.
Mr. Danielski available on July 10th, either 9 or 1:30. And I don't know, Ms. Hudick, what's best for your schedule, 9 in the morning or 1:30 in the afternoon for a review?
9 in the morning, or no, 1:30. It doesn't matter.
Oh, okay.
Either 9 or
Mr.
1:30.
Danielski, any preference, whether 9 o'clock or 1:30?
Either one's fine with me, Your Honor.
9 o'clock.
July 10th at 1:30.
I'm sorry, 9 o'clock, or what's better for us?
1:30.
Okay, 1:30 is best for us. So, Ms. Anderson, if you could please put an additional in the recommendation, call review parenting time, July 10th at 1:30 via Zoom. So keep the court Zoom ID number, Ms. Hudick, and check in if there's some issue between now and then, bring it to the court's attention at that time. So we're not, so you don't have to file any type of motion to modify parent time. We can address it at that time if there's some issues. But Mr. Lewis is very critical that both you communicate with each other. You can't talk, sit on the phone, then text each other. You should obviously let the other know how the child's doing. And particularly where the child's going to be when you're working. That's important. Right, anything further, Mr. Danielski?
No, Your Honor.
Ms. Hudick, do you have any other questions, concerns?
No, Your Honor.
Okay, so let's make sure we are on the same page. Today is Thursday. So we're gonna start dad's parenting time then on Friday, right at 6?
That's fine, Your Honor.
Ms. Hudick, is that agreeable?
Yes.
All right, so 6 o'clock on Friday, you're gonna meet at the Woodhaven Police Department. And then, of course, you'll meet again on Monday, even at 6 o'clock. And child will be returned to you. So dad will have the child. And Mr. Lewis, obviously keep mom informed. You can just short text message. Ivy did well. Ivy's in bed, sleeping. Or just, you give her some peace of mind knowing the child is doing well. This is the right thing to do. And it will assist in your relationship. The two of you need to work together for the next 16 or the next 12 years of this child's life.
And this includes, he's not allowed to leave the state?
Correct. And it applies to both of you. Without your consent, if he's going somewhere out of the state, he needs to notify you, and your consent should not be unreasonably withheld. If he's going to Toledo to a zoo, that should not be unreasonable. But he'll notify you if that happens. Presumably that's just for a day trip.
Okay.
All right. So again, meet at Woodhaven Police Department on Friday. It's tomorrow, 6 o'clock. And Mr. Lewis has a car seat?
Yes, he does.
Okay, very good. All right. That concludes here, and you can, we can zoom out, have a good rest of the day.
Thank you, Your Honor. Have a good evening.
You're welcome. Thank you.
Thank you, Your Honor. That updated recommendation should be in your queue, Your Honor.
Thank you, Ms. Andrews. So we can stop the clock. So Seth Evans versus Jessica Brubaker For the record, this matter is before the court for a pretrial scheduling conference per the last consent order of this court of April 5, 2024. This hearing is being conducted via Zoom. Present is Attorney Christina Hills, representing the plaintiff, Father Seth Evans. Mr. Evans appears to be present with, there's Mr. Evans, okay. In addition, Attorney Ron Bruce is present, representing defendant Jessica Brubaker. Ms. Brubaker is present. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
If the court recalls, the plaintiff's motion to modify custody remains pending. Is that correct?
It
Ms.
is, Your Honor.
Hills?
We also have a pending sentencing on contempt finding, which Ms. Brubaker had agreed previously that she was in contempt of court for parenting time violations.
Find that order. So what are we going to do with the motion to modify custody?
Your Honor, at this time, things are going better. A little blip with regard to the AppClose calendar and a dentist appointment not showing up. Ms. Brubaker says she put it on there, but it did not show up on my client's end. But other than that, AppClose seems to be helping quite a bit to the point where my client is willing to withdraw the custody motion without prejudice. We still would like to move forward on the contempt sentencing. And he is asking for an award of attorney fees with regard to the contempt.
Mr. Hills, what's the day of the order of contempt? Right,
I believe it was 2 orders ago. I'm sorry, I should have had that out.
there was a hearing or an order entered on January 16th indicating attorney fees and sentencing on the show cause are reserved pending further motion. Subject to that, Ms. Hills did file the motion. So, Ms. Patrick, if you could prepare an order to the court that just notes that plaintiff is withdrawing is without prejudice his motion to modify custody at this point in time. At least that issue has been addressed. Have the parties completed the high conflict solutions workshop and provided essays to the front of the court?
I believe that my client has, yes, and he's nodding.
Ms. Patrick, has your office received essays from the parties?
Let me double check that, Your Honor.
Right. Mr. Bruce, did your client complete the program?
Not sure. Ms. Brubaker, did you finish that?
Okay. Ms. Brubaker, did you submit an essay in terms of what you learned from the class to the front of the court?
Yeah.
I didn't know we were supposed to. I don't think Seth did.
Yeah, Your Honor, I completed the high conflict thing. I did not write an essay to the court, no.
Okay. All right. Did you get a certificate verifying your completion of the program? Mr.
Yes.
Evans? Okay, Ms. Brubaker, you likewise got a certificate?
Yeah.
Okay, did you learn anything from the class? I'd like to hear from both of you. I mean, I don't want to order people to take this class if it's a waste of time.
Your Honor, I did learn a lot from the program.
Okay, so you thought it was worthwhile, Ms. Brubaker. What about you?
Yeah. It was a long time ago.
The idea is to help you co-parent.
Your Honor, just for the court's information, I do find the certificate for Ms. Brubaker. I did not find Mr. Evans yet.
I have his certificate right here in front of me, Judge.
All right. The court's satisfied. Both parties have completed the program. Thank you, Ms. Hills.
Thank you. And the order, the date of that order where Ms. Brubaker acknowledged being in contempt of court was September 12th, 2023. We had been adjourning for review hearings and adjourning the sentencing date to try to gain Ms. Brubaker's compliance with the parenting time orders in this case. That's why this is stretched out for as long as it has. Finally, we gain compliance to a large extent to the point where they appear to be co-parenting pretty well. But in the process, my client has spent over $4,000 in attorney fees to get what he should have gotten right out of the gate with the judgment of divorce. So we are asking the court to have Ms. Brubaker reimburse him the $4,014.50, which he has paid me, not including our time today.
Right. The The contempt was due to the court's determination that Ms. Brubaker had denied father parenting time. Is that correct?
That is correct. He is denied summer weeks of parenting time. He has been denied that. He's been denied weekend parenting time. He's been denied multiple holidays of parenting time. He has attempted to attend school events for the minor child, only to show up in Cleveland for those events and find out that mother had held the child out of school on those days with no communication whatsoever to him. There have been she shut him out, left him off of school paperwork, no mention of a father whatsoever. That had to be rectified. And we've had numerous things like that over the same period of time. Mr. Evans bent over backward to give her the benefit of the doubt, to try to get things right. And review hearing after review hearing, we continued to have problems. So I'm really glad that we're at the point that we are, and they seem to be co-parenting pretty smoothly. But again, he spent over $4,000 getting here.
Thank you, Ms. Sills. That does refresh the court's memory. The court did find Ms. Brubaker in contempt of court for violating parenting time. And with respect to sentence on that, which has been adjourned a number of times, Mr. Bruce is, of course, inclined to assess costs or fees rather than any type of incarceration. Obviously, we want Ms. Brubaker to be actively involved in the child's life. What's your client's response, Mr. Bruce, in terms of the amount of compensation to be paid to Attorney Hills?
Well, Judge, we would argue that the $4,000 is excessive, that the parties have worked through these issues. Both parties make decent income. Both parties have attorneys. The issues have resolved themselves. I think she would dispute that there was a lot of what Ms. Hills indicated in regards to my client being culpable for dad missing time. Clearly, dad could have signed himself up to school paperwork. I think a lot of it came down to a breakdown in communication that they resolved themselves through the app flow. My client indicated that she'd be willing to pay $500 towards settlement of this to reflect, the show cause. But a lot of these reviews, I don't know if they necessarily were necessary. Basically,
well, Chris, there were. Again, the court has a busy enough docket then to keep holding hands of these two parents every 60 days. And there's been a lot of reviews, and it should not have been necessary, Mr. Bruce. So this time the court will order that Ms. Brubaker pay $1,000 to Attorney Christina Hills. And can that be paid within 2 weeks, Ms. Brubaker?
Sure. Yes.
Okay, that should be paid on or before June 14th. $1,000 to Ms. Hills. And Ms. Patrick can put that in the court's order that the plaintiff withdrawing her motion to modify custody at this point in time without prejudice. And Ms. Brubaker, the court would hope that you learn something in the class. You need to start co-parenting. You owe that to your child. Co-parent.
Your Honor, what was the time frame to pay the Ms. Hills the attorney fees?
$1,000 on before June 14th.
Thank you, Your Honor.
Right. All right. Anything further than this afternoon, Ms. Hills or Mr. Bruce?
no, Judge, thank you.
All right. That will conclude this matter. Everyone can zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you, Your Honor.
Welcome. Thank you, Ms. Patrick. Court will call the case of Kyla Hall versus Robert Dean Hall. This matter is before the court for continued pretrial conference subsequent to mediation with the front of the court. And this hearing is being conducted via Zoom. President is Attorney Eugene Ferguson, representing the plaintiff, Kyla Hall. Ms. Hall appears to be present with Mr. Ferguson. In addition, Attorney Walter Skatinsky is present, representing defendant Robert Hall. Mr. Hall is appearing this afternoon via Zoom from the Monroe County Jail. Good afternoon, everyone.
Good afternoon, Your Honor.
The court has been informed, Mr. Walker, that the parties have reached an impasse and were not able to reach their own agreement. The court notes this is a relatively short-term marriage of 3.5 years. The real estate property has been sold. What is the sticking issue, Mr. Ferguson?
Division of assets.
I understand. The real estate's been sold, so division of the cash?
Division of the cash, yes.
All right. And you're holding the proceeds from sale of the home in your trust account, is that correct?
I am, Your Honor.
How much is that? Approximately.
Did you want the amount?
Yeah, just approximately.
Yeah, no, I'll give you the exact amount. $37,638.08.
I'm sorry, can you repeat that? 86,000?
No, 37,638.98.
Okay. And we have some personal property. What do you say, other assets? What other assets need to be divided?
There's a
Profit sharing
401k.
check?
There's a 401k. There's a profit sharing check. There's, I think, several ATVs, miscellaneous personal property.
There's also, the wife has a 401k also.
Okay.
You have a 401k?
I think so, yeah.
Okay, come on, haven't we completed discovery? Obviously, we're not prepared to mediate if we don't even know what the assets are. You want a trial date?
Yes, Your Honor.
Have you completed discovery, Mr. Ferguson? Come on, you don't even know if your client had a 401k and you're telling me you completed it, you're ready for trial? Mr. Ferguson, this court doesn't give out trial dates like candy. What, again, why can't we divide equally the proceeds of sale of the home? Is there a premarital asset?
There are
The ATVs.
there are premarital assets.
We'll do quadros on two counts. We spend a lot of money on multiple quadros where maybe we just look at the current values and maybe they're relatively equal. Each keeps their own. We're talking about 3.5 year marriage. I'm missing something, Mr. Ferguson.
This is a 3.5 year marriage. The defendant is now in jail because he committed.
I understand. The court's aware of that, Mr. Ferguson. This is a divorce case. Why can't we divide equally the proceeds and sell the home unless it's a premarital asset?
He believes that she's entitled to more of it because of.
On what basis?
The sex crimes include.
That's a civil action. Take a civil action if you believe that there's some damages. I mean, this is a court of a divorce court. And I'm not sure on what basis you think that she should get more than half of the proceeds.
What? Because he's at fault for the marriage breaking down, and
there's no fault divorce. It might be, maybe you might do a 60-40 split, but not much more than that. It's a no fault divorce. Court can't deviate much from an equal division of assets, Mr. Ferguson, to be overturned by the Court of Appeals.
Okay.
Mr. Kaczynski, what's your take on this?
I agree with the court's assessment on this.
Okay, the ATVs, let's liquidate them. It's not like we divide cash. How many ATVs do we have?
Two.
Okay, and the reason why they can't be sold. Now it's time here to sell them. In whose name are they titled?
One doesn't have a title on it, and the other one is to Rob.
Yeah. One's untitled, one's in his name.
Okay. Mr. Kaczynski, why can't we sell both of them?
I have no objection to that.
All right, so ordered. And Ms. Hall should go to Secretary of State, get a title, a duplicate title for the one ATV that doesn't have a title, and they should both be sold, marketed, put a sign in the yard. I'll take care of that. Okay, we don't know the value of.
Well, Your Honor, let me just say this: I thought you were talking about the motor vehicles. The ATVs are premarital. My client purchased those prior to the marriage.
Okay.
And I believe she disputes that as to one of them.
Mm-hmm.
And that was one of the problems we had trying to settle it, is that he says certain things are premarital. He says they weren't.
There should be documentation. There should be a bill of sale. There should be when was the title issued? Was it issued before the marriage or after? Well, the council needs to conduct some discovery. What is this? Is this a $10,000 ATV? Is it really worth arguing about? How old is it?
It's a 2014 and a 1995, Your Honor.
How much is the 95 one worth? A couple $1,000?
I only paid $400 cash personally from a relative.
What's the 2014 worth?
Roughly 6,000.
Okay. Was that purchased before the marriage?
Yes, Your Honor. It was purchased
Okay.
brand new in 2014.
There were many assets that we disagreed as to whether or not they were premarital. That was part of the reason why we couldn't resolve it. He wants to say that all these tools are premarital and he gets them. And
okay. All right. Well, if it's premarital, then the court's not going to have to be sold. So the parties want to litigate then, because that's where we're starting racking up the fees. But I want discovery to be completed before I schedule a trial date.
Okay.
So you need obviously you need to verify with your client the value of her pension, or Mr. Kaczynski, you need to subpoena that information if Mr. Ferguson's not willing to respond to an interrogatory.
Yeah, I will. I was going to be sending some interrogatories to the plaintiff, Your Honor.
Right.
I'll do the same.
What's the status of Mr. Hall's criminal case? When does he have trial date set?
I believe that there's going to be a plea in the next week or two, Your Honor. That was the latest information that I had. Rob, do you know when the next court date is?
I believe sentencing should be June 20th.
Yeah, I understood that he's already pled.
Well, if he's got a sentencing date, he's already pled, Mr. Kaczynski.
Right. Okay.
What did Mr. Hall, what did you plead guilty to?
3 counts of 3 different felonies.
Okay. Have you talked with a probation agent? Do you have any idea what's being recommended in terms of sentence?
They're recommending 3 years.
3 years prison?
Prison, yes.
Right.
I mean, my client indicated it was 4 to 15.
Right.
And she's involved because her daughter's victims.
Okay. Again, but this is not a civil action, Mr. Ferguson. This is a divorce action. We're looking for equitable distribution of assets. We're not going to take into account that Mr. Hallman is a perpetrator of a criminal offense against the plaintiff's daughter. So how much time do you wish to complete discovery? 60 days?
Yes, Your Honor.
Mr. Ferguson?
2 days is fine.
Okay.
There's also the issue that the assets have to be out of the house before then. And I haven't been allowed to get any of my personal property.
Well, your mother perhaps can facilitate that, Mr. Hall. Obviously, not going to be, you can't wait 3 years to get your personal property out of the home, so you're going to need a family member to help. Mr. Kaczynski can help coordinate that.
Yes, Your Honor.
Is that an issue, Mr. Kaczynski? Do you need a date? You can always petition the court if you need some.
Your Honor, I think my client has attempted or my client's mother has attempted to make arrangements to pick up some of the property, but they've been rebuffed. So I can talk with opposing counsel, and we could set up a specific date and time to have my client's mother retrieve his personal property. We could, I think we could get that taken care of.
Yeah, I would have liked to have thought that those things could have been discussed today. You had a mediator here trying to take some small steps. If you can't settle it, take some small steps forward to move in that direction. All right, so the court's going to propose, when we take the proofs today, at least we can stop the court's clock, and then we'll set a continued pretrial conference in about 60 days, unless counsel has other alternative suggestions. And if we don't have any, if we're not close to resolution, the court at that time would schedule a trial date, but not until discovery's been completed.
Fine.
You're also holding a profit sharing check, Mr. Ferguson. What is the amount of that?
I don't know the exact amount. I believe we think it's about $10,000. I've been in communication with Ford, the lawyer, and he told me just today that he was going to resolve it and get it to me, but I have not received it as of yet.
Okay, but you believe it to be about 10,000?
Is that correct?
It'll be less than 10,000 after they took taxes out, but yeah,
Okay, so more like 10,000 pre-tax, maybe
yeah,
7,500 or so.
yeah.
Right, so perhaps Mr. Hall can provide a list to his attorney of what he wants out of the home. And Mr. Hall's mother can make arrangements, a coordinated date to pick up and retrieve those items. When does Ms. Hall have to vacate the marital home, Mr. Ferguson?
45 days from closing, which was what, weeks ago?
Yeah, July 4th is my last day I'm allowed in the home.
Okay, so we got about 30 days then. Any objection to the court taking the proof stated to establish jurisdiction, there's been a breakdown, no chance of reconciliation, then the court can reserve all issues. Any objection?
No, Your Honor.
No, that's fine.
All right, Mr. Rizal, can you both please raise your right hand? Ms. Ferguson, if you can begin with Ms. Ferguson. Ms. Hall, please. Sorry.
Your name is Keila Hall, correct?
Correct.
Were you married to the defendant, Robert Dean Hall, on or about September 19th of 2020?
Yes.
At the time of filing this complaint, had you been a resident of the county of Monroe for at least 10 days in the state of Michigan for at least 180 days?
Yes.
Separated from your husband on or about January 11th, 2024?
Yes.
There are no children born to the marriage?
No.
And you're not currently pregnant?
No.
Has there been a breakdown in the marriage relationship? You say have been destroyed, and no reason why the marriage can be preserved?
Correct.
Is there any chance of reconciliation?
No.
No further questions.
Thank you, Ms. Ferguson. Mr. Skatinski, do you have any questions of Ms. Hall?
No, Your Honor.
Okay, questions for Mr. Hall, please.
Mr. Hall? Rob?
Yes.
You heard the testimony of your wife relative to the her residency, the date and place of your marriage, and the fact that there's no children born as issue of the marriage, and that she is not pregnant, correct?
Correct.
Was all that was her testimony true and accurate?
Yes.
And you also heard her testimony that there was a breakdown of the marriage relationship to the extent that the object of matrimony are destroyed. There's no likelihood the marriage can be preserved.
Correct.
Is that correct?
Yes.
Nothing further, Your Honor.
Thank you, Mr. Skatinski. Mr. Ferguson, do you have any questions, Mr. Hall?
No, Your Honor.
Right, based upon the testimony that's been presented this afternoon, as well as the complaint filed in this case, court finds that jurisdiction has been established. Court further finds that there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. At this point in time, the court will simply reserve all outstanding issues and schedules for another continued pretrial conference. Mr. Hall, I'm sorry, but once again, what is your sentence date?
June 20th, I believe, Your Honor.
So obviously, if we're scheduling a pretrial in 2 months, Mr. Hall will have to appear from whatever correctional facility is located at. So Mr. Skatinski, you have to let us know where he's at so we can make arrangements to have him communicate via Zoom. It'd be nice if the parties can resolve this before June 20th. So we're looking for a pretrial in August. You need 60 days, correct, for discovery?
Yes.
So, how about August 9th, Friday, August 9th?
That's fine with me, Your Honor.
Yeah, I have a Wayne County evidentiary hearing that day.
Okay. How about August 16th?
It's fine with me, Your Honor.
Yeah. I hate to say this, but I have a wedding that day.
Okay. The 23rd of August?
Fine with me.
That's good.
All right. 8:30?
8:30?
Correct.
All right.
How about, it's been suggested maybe do it at 10 o'clock, just in case there's if we have difficulty with the correctional facility, might be both of them at 10 o'clock.
That's fine.
Okay, so August 23rd, 10 a.m. And that'll be a final pretrial. The court suggests if in fact you want to continue discussions, I'm sure you can reach out to Mr. Walker and schedule continued mediation, but the court's not going to order one at this time. If it's not resolved by August 23rd, well, at that time we'll schedule for trial.
Thank you.
You're welcome. Anything further, Mr. Ferguson or Mr. Skatinski?
No, Your Honor.